So today's webinar is focused on slip and falls. We've got from sidewalks to settlements, how to manage slip and fall liability. And I do want to take a moment to thank the Greater Cincinnati and Northern Kentucky Apartment Association. I know a lot of you tuning in are a part of that association. We're also very grateful for you guys' participation and for you guys bringing people to this webinar. So thank you. So let's go ahead and jump into just a quick agenda and overview of today's webinar. So we're going to talk about what to do to prevent a fall, some of the top things that property managers overlook after a fall and how to protect yourselves there, how attorneys really build and win liability cases, and again, how to protect yourselves there, what insurers flag as preventable, and some strategies that you guys can do to protect your brand if you do experience a liability lawsuit. So some quick introductions. My name is Jen Free. I've been with Cloud Structure for about 4 years now, but prior to that, I worked on site on the operations side of the property management industry as a property manager in a regional. And so I am very familiar with what you guys deal with on a day in, day out basis and the liability that you guys see often with these liability lawsuits. My background really provides that passion that I have towards protecting multifamily communities from that liability. And I'm very excited to be hosting today's webinar. So also on this call, we have Melinda Macbeth. She is counsel for Offutt Herman, and she is a leading litigator who specializes in landlord defense and liability law. She brings a legal insider's perspective on how slip and fall cases are built and how to really safeguard yourselves against them. So thank you, Melinda. As always, we're really excited to have you and your expertise here.
Thank you. Happy to be here again.
And next, we also have Megan Davidson, who is first vice president for Alliant Insurance. Really excited to have you here, Megan. Megan is a risk management pro who helps multifamily portfolios navigate insurance claims and reduce exposure. So she's going to be sharing some proactive strategies to help lower risk. So again, Megan, really excited to have you here to answer some questions specifically targeted towards insurance.
Thank you.
So let's go ahead and jump into just a quick overview of each company that is participating on this call. So I talked a little bit about Cloud Structure. We really focus and specialize in AI surveillance and remote guardian services in the multifamily community. And so we really focus on providing that proactive aspect to security, being able to stop unwanted activity from progressing into crime, liability lawsuits, property damage, lease violations. So we really add that proactive factor by adding that speaker, having that live agent in conjunction with the AI analytics to really hone in on making the security the top priority for each property. And we're really able to customize the security solution for each property based on each property's needs, because every property is so different in what they're faced with. And so we'll talk a little bit about how having coverage and surveillance and that proactive piece can really help protect you in the future from liability lawsuits. Melinda, would you like to talk a little bit about Offutt Herman?
I'd be happy to. Offutt Kerman is a full service civil litigation law firm. I wouldn't call us national yet, but we're getting there. We continue to open offices in different states. Most recently, we just announced within the last month or so that we are going to be having a presence in Atlanta, Georgia. We have offices in Florida, in Los Angeles, pretty much all up and down the East Coast. I am based out of the Baltimore, Maryland office. We also have offices in DC, Virginia, North Carolina, South Carolina, Pennsylvania, Delaware, New York, New Jersey. Basically, if you're in the United States, we can probably help you. We have different practice groups that do all sorts of services for family law, divorce and custody, all the way over to landlord tenant, which is, of course, what I do. I am part of the Maryland Landlord Representation Group. But we also have attorneys who handle landlord matters in DC, Virginia, New York, New Jersey, all over the place. So if you are interested in learning more about what we do, feel free to reach out to me after the webinar, and I'd be happy to chat with you.
All right, Megan, we'd love to hear a little bit more about Alliant and your company.
You bet. Alliant is probably the biggest brokerage you may not have heard a lot about, but we are now fifth largest in the nation, primarily employee held, which makes a big difference in the way that we navigate working with both our clients and each other. We are specialists in my vertical in multifamily risks. So we do about 2.5 million units annually, insure 2.5 million units annually. All our practice group is focused on is that. So loss control claims, every line of coverage you can think of, we have a specialty in. I've been in the business, we're just going to say over 30 years. So have seen and done a lot in the multifamily space. About 27% of what we do is affordable, which can be challenging. And we do either affordable or we do market rate. Love it all.
All right, so let's go ahead and jump into it, guys, what you guys are so eager to hear and learn about. But first and foremost, I kind of want to cover some of the data surrounding liability lawsuits, slip and fall cases. It's a huge risk that you guys take on every single day. And up on the screen here, you can see some of the cost factors that certain properties can be faced with if facing a liability lawsuit. It's huge. Medical costs alone from staying in the hospital, 30 to 40,000. You can see the state of California is higher just because of how tenant friendly it is there. So you really have to hyper focus on how to protect yourself nationwide, but specifically California. And at the bottom, you'll see a sad statistic. More than 16,000 people die every single year from slip and falls, and a significant amount more go to the hospitals due to injuries. So it's a huge thing that is very important to take into these important things into practice to, again, protect yourself from this liability. And so, Melinda, I'm curious, how many lawsuits do you see filed by a resident every single year? And what do the outcomes tend to be?
It's hard to put a figure on it. I can say that the amount of claims being made against landlords seems to be increasing, at least in Maryland, because of the climate that we're dealing with now, where there's a presumption that the landlord is always wrong and the tenant is always right. And I think that now that news has sort of trickled out to tenants that they can sue their landlord and get some money out of them, it's opened the floodgates a little bit. So I would say that I deal with probably at least a dozen every year. But a lot of my clients also will not send these types of cases to me. They'll go through their liability insurance carrier, who will often provide them with separate counsel and representation, which I am fine with because it's usually cheaper for the landlord to go through their insurance as opposed to, paying me or one of my colleagues to do it. Typically the minimum amount that they ask for is 30,000, but I've seen it go all the way up to into the hundreds of thousands. And it just depends on the nature of the accident and the plaintiff, the person who's bringing the case. If they had issues already and then they had this accident, you are kind of liable for whatever happened. There's something called the eggshell doctrine, meaning assume that this injured person has a skull made out of eggshells, right? It's very easy to break. It doesn't matter that they were already kind of predisposed to have an accident like this. If the accident occurred on your property, then you're potentially liable for it and for all of the complications that might arise because of this person's other issues that they have going on. So it's something that, and even one case could cost you $500,000, $1 million. It just really depends.
Talking about taking those preventative measures to protect yourself, your company, your property. And Megan, I'm curious if you could talk about from the insurance side, are slip and fall cases going up or down annually? And how do you really account for any shifts in the volume of cases?
The answer is yes. So, I mean, the easy answer is yes. Claims are going up. I want to say exponentially, it feels like. But if you think about it this way, the plaintiff's bar is spending over $2 billion annually on billboards. So if you're driving down the road, depending on your state and what the rules are on billboards, you are going to see billboards announcing Rafi, 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 or Sweet James, or whomever it is. They are spending billions of dollars to advertise that they will help everybody with everything that ever happened to them. If it's an accident, they're on it. So the other issue is the value of verdicts has gone up so much. There have been two huge verdicts that have come through the court system in the last few years, one of which for slip and fall. And this particular one was for pooled water on a job site. $58 million for a slip and fall. The other one was a slip and fall, and it was in Vegas. And again, it was pooled water, and it was a $16 million verdict. So just assume if something happens, someone's going to try and make it your fault because people are advertising that they can help you. And so for me, the promise of great enrichment has driven a lot of folks to try and seek help through the court system. And the problem is most folks are not carrying limits of $60 million unless they have a really tremendous portfolio. But as the cost of excess liability goes up, people have been reducing those excess liability limits. And so it becomes even more important to try and avoid claims in the first place.
Let's go ahead and start jumping into some of the things that you guys need to be on the lookout for and how to proactively protect yourself. So very first, before a fall happens. So Melinda, from a legal standpoint, what are some of the most common oversights that property managers make before an incident even happens?
So I think it's just not paying attention to the little details. Either it's not walking the property enough or frequently enough, or just not noticing small things that could turn into big things when they do. Things like poor lighting, uneven walkways. If there's electrical cords that are crossing the sidewalk or whatever, somebody can trip on that. There's loose carpeting in a unit. That's a tripping hazard. Transitions from carpeting to hardwood or whatever, those are tripping hazards. You have to just look at every little thing. Are there tree roots that are exposed? Are there handrails that are loose on the stairs? Are there sprinkler heads that stick out of the ground a little bit, but not enough that they would be obvious to people? That's a tripping hazard. Somebody could just not be paying attention and they walk by and they trip on that, and then you have a big problem. I think if there's garbage around the property, that can sometimes be a good indicator of poor management or just of management not paying attention, because that sort of shows that there's a lack of attention to detail. Make sure that your balcony stair railings are spaced correctly. If they're too far apart, then that's a hazard for little people. Babies and toddlers could potentially get their head stuck in there, get their whole bodies through there, and then you've got a pretty big problem on your hands if you have an injured child. Pay attention to the weather. What is generally the weather like in your area? Do you deal with snow and ice in the winter? Do you deal with lots of heavy rain in the summer? Here in Maryland, we kind of get all four seasons at any given time. So, things like pooling water, which has already been mentioned a couple of times, or there's a patch of ice somewhere. And sometimes, as property managers, you guys will figure out where the problem areas are. Like this particular section of the sidewalk, it's slightly lower than the rest of it. So it pools water there, or there's always an icy patch right here in the winter. Like those are things that you guys should be paying attention to and either fixing if it's something you can fix, or provide warnings to your tenants. Put up a caution sign so that at least that way you've made an attempt to warn them to don't walk right here, there's a hole in the ground, whatever it is. Those things can go a long way.
Okay, so you've talked a little bit about some of the do's and don'ts. How does the court actually weigh implementing proactive measures such as surveillance footage, documented maintenance schedules, or even remote guarding alerts in determining whether or not a property owner has met their duty of care?
It varies. It depends on where you live, what state you're in, because each state has different laws when it comes to liability. But at least in my state, in Maryland, courts will look at, was the danger open and obvious, and was this foreseeable, right? If you've known about this exposed tree root or these sprinkler heads for a while and you've done nothing about it, then that's potentially a problem, because you knew that there could be an injury occurring and you didn't do anything about it. If you don't warn people of known dangers, that's potentially a problem, because that is part of your duty as a property owner to give them a heads up about things that they should avoid. Also, I think sometimes what can be very helpful is just knowing what happened, whether it's good for you or bad. If you have security cameras or surveillance around your property, sometimes it's going to show you things that you don't want to see and you don't like because it doesn't look good for you. But at least then you know that it happened and you are able to address it in a timely manner and potentially prevent it from happening again. Sometimes the security footage will help you because it'll show that there was no accident, or there was an accident, but that person was not paying attention and they contributed to the accident, which in some jurisdictions is a defense to the claim. They were they wearing 9-inch heels in the winter and walking on the grass? That sounds like a risky thing that they chose to do to me. Or were they talking on their phone and not paying attention to where they were walking? All those sorts of things matter when you get into the litigation stage because you're trying to figure out why it happened, how it happened, and who contributed to what happened. Sometimes it's the person who was injured, and sometimes it wasn't. But at least when you know,
Right. There's such a variance of factors that come into play when talking about stuff like that. And so Melinda has spoken to how much it can differ from state to state. We went ahead and put a link in the chat that talks about some of the negligence laws and how they vary from state. So go ahead and check that out if you're curious about your state specifically. Megan, I want to take it over to the insurance perspective. What kind of preventative measures do underwriters actually want to see in place?
So it's interesting. Underwriters, when they're looking at a risk, there are things that they put on paper, and then there are things that they're allowed to give you credits or debits for that are not on paper. So one of the things they would like to see that they may not ask for is they may ideally like to see what your response is to an incident. So having a really good incident report so that if something happens, you have a plan in place is important. But I also like the idea that before a loss ever happens, are you talking to someone in risk control that either works for your insurance brokerage or for the insurance company? What is the procedure you have in place? How often are you walking the premises? What does that checklist look like? And if I had one recommendation for anyone, it's that from the top down, everyone in an organization considers risk management everyone's issue. If you do that, you'll see some of the things that I see. When I'm walking a property with owners or property managers or things like that, I have seen owners of properties reach down and pick up a piece of garbage or say, there's a pothole in the parking lot. We need to address that right away. So making risk management everyone's responsibility becomes really important. And then not just doing those actions, but telling your broker about it, having them be aware of your procedures so that they can then go to the insurance company and say, listen, insurance company, here's everything we're doing. Having a really set, if you're in the right area or the wrong area, as it turns out, having a snow removal procedure in place, having a contract so that that gets done, following through. If someone doesn't show up when they're supposed to, calling them. Hey, where are you? We've got an issue. I was in Washington previous to being in Arizona, and in Washington, I had a property that I walked across. It was solid ice and had been that way for a week. And all I could think of, it wasn't just the parking lot, it was all the sidewalks. And I thought to myself, we have an issue. We have an issue here. So having everyone be aware of risk management, I mean, you have in front of you really the key issues you want to be looking for, but what's your procedure for dealing with those? Saying something, doing something, and follow through are all going to be important.
And so, in talking about risk management, how do insurers kind of evaluate the
Mhm.
relative risk reduction of various kinds of preventative investments? Because there's slip resistant surfaces, you can implement AI surveillance. Which
Yes.
carry the most measurable weight?
That is a great question. The kind of things that insurance companies are going to look at very specifically that they will put in writing is they're going to ask you about your lighting. They're going to ask you about your cameras. They're going to ask you sometimes about your handrails. They are not going to ask you about slip resistant surfaces, which is interesting because those can be so key. And transitions between surfaces also super key. So if you're doing anything that has to do with any of these areas, you need to share that with your insurance broker, who then should be sharing that with your insurance company. So you may be aware of, as an owner or manager, issues that make your property less liable to have a loss, and sharing that with the broker. We'll know what can go into the application, but we also know what to share in any kind of a documentation we can share with the insurance company, what to bring up that will make a difference in rates. Those things can definitely bring up things in rates, even if they're not on the application. We just need to know about them.
So you guys have heard both Melinda and Megan talking about documentation, how important it is. So really just to drill that point home. So let's transition to talking about things that can be overlooked after a fall happens and kind of how to handle the situation like that. So Melinda, I'm curious, when a case lands on your desk, what kind of evidence can make or break the defense?
All of it. Documentation, really. These types of cases, and most of the cases that I handle are won or lost on documentation. I prefer more of it. I want constant updates to the file. If there's something that happened, I want immediate notes to the file from the property manager or whoever it was. If somebody comes into the rental office and says, "Hey, I just fell out on the sidewalk," I want you to start taking notes right away. I want names of who was there, phone numbers, contact information for witnesses. If you have cameras on your property, you need to make sure that you're saving whatever footage you have from that day so that it doesn't auto delete or record over or whatever. I want incident reports in the file, and I want those to be done fairly quickly after the incident, because that way, whoever is writing those reports or putting the notes in the file has a fresh impression of what happened, right? The longer that you wait before you write all this stuff down, the higher likelihood that your memory is going to fade. You might get some details wrong, whatever. So I want your immediate reaction and your impressions of what happened. That can be really helpful for us. Another thing that I've noticed is just keeping in communication with the resident or the person who actually suffered the accident. I understand that the inclination, and it's probably my fault and my attorney colleagues' fault, that we have drilled into your heads, never admit that you were responsible for anything. Don't say as little as possible, because anything that you say could potentially be brought up later. But the flip side of that coin is that sometimes just compassion and sympathy for what that person has experienced will go a long way. One of the biggest complaints I get from litigants when we end up in court is, "Well, I fell and I went and told them that I fell and nobody cared. Nobody cared. They didn't call me the next day to see how I was feeling. They just went completely silent on me." And so just showing a little bit of sympathy and compassion can really go a long way. You can do that without admitting to guilt. You can say things like, "I'm really sorry that happened to you." Call them the next day. "How are you feeling? Did you go to the doctor? Are you feeling any better?" Just check in with them. That giving the impression that you care at all can really be helpful and sort of calm them down. Usually, when people start chasing after their landlord for these high dollar amounts, a lot of it is because they're angry. It just comes down to raw emotion. I would make sure that if you identify that there's anything that needs to be fixed because of the fall, I would go out there and take steps to fix it. Doesn't necessarily mean that you're admitting to any liability, but you're cutting off the potential for future liability when you do that. If you are making any changes to your policies as a result of something that happened, be transparent about that. Let your tenants and their guests know that this is what's going on. Again, if they think you don't care, that snowballs the issue and makes it much worse.
And talking about sympathy and empathy, offering that is free. It doesn't cost you anything. And yet again, you've talked about how important and how far that can take you in offering that. I am curious, so many questions surrounding this. So what about ownership versus management in a slip and fall case? Who really has that exposure to the risk?
Oh,
Probably,
both.
probably both. Yeah, both.
Yeah.
And when these, we talked about the billboard attorneys, the ambulance chasers, the lawyers that really do this type of work, they will go after whoever they think has the deepest pockets.
Mhm.
Sometimes they'll just name everybody. They'll name ownership, they'll name management, they'll name, if they think there was another tenant that maybe caused the issue, they'll sue them too. But they understand that that's probably the place, that's not where the money is. They're going after the deep pockets. So it really depends. I most often see everybody pulled in.
And what that does bring up the importance of contracts. So the first thing we always talk to somebody about when they're going into, particularly a property manager, when they're heading into an agreement with an owner, we say, let me see your contract. Everything stems from that. If the contract wording isn't done properly, liability isn't as clear as it should be. So you want everything up front. And the other issue I would say when we're talking about overlooking after a fall that comes to mind is, I'm going to throw a scenario out to you because I just viewed a video in this last week, and we had a property owner who had a slip and fall. And I said, where's the video? Do you have video? Absolutely. So they sent me the video, and just picture this. You have a fellow and he has a prosthetic leg. You see him walking down the sidewalk unsteadily, which looked like a bit more than just the prosthetic leg. He's walking down the walkway. He comes to a two-step transition from the sidewalk up to the property entrance. He holds onto the handrail. He gets to the top of the steps. He's very unsteady. He's leaning back, and all of a sudden he leans back and he falls back to the sidewalk, down two steps. There was nothing wrong. Everything you saw in that video is the fellow was unsteady. Now, I have great sympathy for the fact he fell. And my goodness, who wouldn't? He's disabled to begin with. But was there an issue with the property that made it unsafe? It didn't appear there was any. That video is going to save both the owner and the property manager a lot of heartache. So instantly after something happens, the first thing you should be doing is pulling video. And then if there was anybody, if there was a tenant who saw something, perfect. Was the lighting on? I could tell that the lighting was good by the video, right? All those elements are really important. How was the lighting? How was the video? Were there people who saw it? Every single thing should be documented, and make sure that that video is saved beyond 30 days. Most companies who have surveillance or who offer surveillance may say in the contract, we'll hold it for 30 days. Just call them. They'll save it as long as you need it. Pull it. They'll save it on a zip drive or whatever, hand it to you. They'll save it as long as they know there's an issue. So all of those elements are really important. And I think to Melinda's point, if there was something that made a situation unsafe, fix it. Fix it right away. Because if you don't, and a second incident happens, you were unaware the first time potentially, but the second incident happens, your liability is going to go up so exponentially. That's a real concern as well.
And so
Mhm.
this question is kind of for both of you, but when you're advising a client on a slip and fall case, what are the biggest red flags that kind of make you decide, whether internally or externally, to instantly make a settlement offer?
That's a great question. Listen, the minute that you have insurance involved, you basically provide the insurance company with the ability to settle or not settle. Now, the information you give the insurance company is key as to whether or not they feel a settlement makes sense or not. I also want to throw out, in a lot of cases, you have the ability to work with the insurance company to say, would you please work with a particular attorney? Now, the attorney has to agree to a different, to a set rate. But you're listening to Melinda speak. If you wanted Melinda to be the attorney you work with, talk to the insurance company, because you may know that the way they navigate settlements aligns with the way your organization feels about something. So you can give your insurance company your opinion on whether or not you want to settle. But in the end, if the insurance company is going to pay for the settlement amount, they have the right to determine whether or not something settles.
And
Right.
that's often a numbers game, right? How
Yes.
much is it going to cost us to
Hmm.
go through this litigation versus how much is it going to cost us to settle? I mean, you could take a case all the way to the end of it and win, but then you've racked up 20 grand in attorney's fees. So it's kind of like losing by winning, So it's
Right.
sometimes, even if you have everything in your favor, it makes more sense to settle just because it's going to cost you less at the end of the day.
And
Right.
Melinda, you give guidance all the time, I'm assuming, to insurance companies to say, listen, it's going to cost this much to litigate, and we can settle for this amount.
Hmm.
And that really typically those numbers are going to determine what the insurance company does.
That's right. Yeah, I mean, sometimes, a lot of times when these first come onto my radar, it's just, hey, can you reach out to this litigant or this attorney and just get a sense of if they'd be willing to settle and give me a ballpark of what they'd be willing to settle for, and then if we make the determination that it's not appropriate for a settlement, sometimes they keep the case with me, sometimes they take it to different counsel who does these types of cases more frequently than I do, but it's good to sort of get a overview of where you think it could head. Obviously, you never know for sure, but sometimes you find a litigant who is willing to settle for a relatively low dollar amount, and you can say, I think it's worth it just to pay them this to get it over with, get a full release. That way, this never comes back to bite you ever again. It's done.
That is helpful. Thank you to both of you for answering that. And there's an interesting question in the chat before we go ahead and move on, but I think this goes back to a previous statement that we were talking about. But on the flip side, when a resident is suing for a slip and fall, claiming serious injury, but I can still see them going out for a jog while waiting on a court date, can I pull the surveillance footage of that? And is that helpful in your case?
Yes,
Yes.
I love it. I think so often there can be a disconnect once somebody turns something over to an insurance company. Do not stop the conversation there. In fact, the call I have right after this is a claims follow up call with one of my clients. And what we do is we regularly discuss incidents. What do you know that we may not know? Particularly workers' compensation, whether it's a workers' compensation issue, which factors into this as well, or it's a slip and fall with a resident, or whatever that issue is. We want to know what people on site might know because it really does help your defense. You can help yourself. And think about it this way, claims convert into what you're paying in premium. If there's a reasonable argument to be made that a claim needs to be settled for less or that the claim shouldn't have been made in the first place, we want to know about it because we want to fight on your behalf. And the insurance company wants to do the right thing, believe it or not. They want to do the right thing. We want to help them do the right thing. Any information you have, please share. If it's video footage, if it's somebody who played softball with somebody who's supposed to have a broken ankle, I mean, let us know. Let us know all this. It all factors in. So
Mhm.
yes, the answer is tell us.
And I think it's our job, the attorneys and the insurance adjusters, to sort of sift through everything that you send over and pick out what is relevant and what isn't, what's helpful and what isn't. I always like to see the big picture. So whatever you have in your file, I want to see it. I want to see the
Mhm.
video, not just of the incident, but the hour before and the hour after, because I want to see if there's anything going on before or after the incident that happened that maybe you didn't think was connected, but I see it and I'm
Mhm.
like, there it is. There's a smoking gun or whatever it is. If this person is out running around on their broken foot, that is highly relevant information.
All right, let's keep going. So, how attorneys build and win liability cases. So, this is going to play a huge part in learning how to really protect yourself. So, Melinda, I'll hand it over to you here.
Yeah, I think I've already touched on some of this a little bit, but the key legal elements in a slip and fall case are duty, breach, causation, and damages. So, first we have to figure out, did the landlord or the property owner have a duty to take care of whatever caused the incident? And if so, did they fail in that duty? Did they neglect in that duty? And if so, did that neglect or that breach of their duty cause or contribute to the accident? And then, if the answer to that is yes, we move on to damages. How was this person hurt as a result of the incident? Hospital bills, pain and suffering, all those sorts of things. And what are they due to make them whole? Depending on how egregious the situation was, sometimes you get punitive damages, which are a punishment. This is, we're going to make you pay this so that you and other property owners around here know not to do that ever again, right? That is, it's a penalty. It's hitting you in the pocket because they think that that's where it's going to hurt. Evidence that I always look for: inspection logs, incident reports, prior complaints. If somebody told you they tripped on the sidewalk, I want to know if you were aware that the sidewalk was uneven there. If you've got 5 other tenants complaining about this portion of the sidewalk, you've got a problem. I want to look at maintenance records. So I don't just want you walking the properties. I want you documenting when you walk the properties. And I want you writing down any issues that you may find or not find. I want you to be pretty specific about it because that is how we win and lose cases is documentation. The property conditions before and after. Were there any repairs needed? And if so, did you make them? Did you make them within a reasonable amount of time? If you did, that is very helpful. If it still looks the same way on the date that you go to trial as it did on the date of the accident, that's potentially a problem. But then you also have defenses. If the danger was open and obvious, that person should have known that there was a hole in the sidewalk there or whatever, then some of that is on them because they weren't paying attention. I love the pro tip, make a note of what shoes they're wearing because the shoes matter in cases like this. If you're wearing high heels or slippery shoes or flip flops on the ice, all of those are poor decisions by the person who was injured that contributed to the accident. And those are things that you can raise in your defense. But for her 9-inch heels, she probably wouldn't have fell.
Right, right. That's huge. And so, in talking about this a little bit more and managing the discovery, what are the most effective ways to really organize and present surveillance footage, documentation, inspection logs, and maintenance records so that they're admissible and persuasive in court? And is there something to avoid so that this very important documentation and footage doesn't become inadmissible?
Well, you want to be able to you have to authenticate any evidence that you introduce in court, meaning you have to prove that it says what you're claiming it says and that it's from the time period that you're claiming it's from. So I would like to see dates on every note to the file, every maintenance report. If there's a property inspection or walk going, I want to know when it happened because if there's no date on there, then it's useless to me. I can't prove when you took that. I want date and time stamps on your
Mhm.
security footage. If it's just here's a video and I don't know when it was took or when it was taken or who took it or any of that stuff, it's useless to me. You also want to make sure, and I think this is the biggest challenge for larger property management companies, is the a lot of this evidence is going to rely on personal knowledge. If you're the property manager, but this incident happened 2 years ago and you weren't there when it happened, your testimony isn't really going to carry much weight and you're not going to be able to testify to the photographs and things like that because you have to acknowledge this is when it was taken and yes, this photo accurately depicts what I saw. That's what you have to prove. If you weren't there when that was taken, it's a problem. Your maintenance guys, if they're the ones writing these notes, they have to be prepared and able to come to court and testify about some of this stuff. You need personal knowledge of a lot of these things to get the evidence through and admissible in court.
And so, Megan, what role does proactive risk management like surveillance and good case management, what does that play in lowering costs and protecting brand value?
This goes back to the same sort of things I talked about when it comes to an incident. If you are doing something, say something, right? If you know something, say something. So there will be very specific questions on an application. The key ones are really going to be they talk about lighting. How many exterior lights do you have? Are all areas well lit? Think about stairwells. How well lit are they? And by the way, those exterior lights don't just help with slip and falls, they are a big deterrent on crime. And how many cameras? Not just do you have cameras? The question is now, how many cameras do you have? And they want to know. Those elements are actually going to specifically be on applications now. Those things that are not on applications are things we mentioned earlier, things like surfaces. Do you have slip resistant surfaces? Handrails are big. My worst day at work was reading about balcony railings being more than 4 inches apart and babies fit through those. So certain things that you can do before the fact that you've gone through your property and addressed all those elements are going to be really, really key, but not all will be on the application. So be sure that those things that you know, whether they're on an application or not, that you let your insurance broker know so that we can share those with insurance companies. They do make a difference. It's in the discretionary credits that nobody specifically talks about, but that are still available. 10% of insurance costs, when insurance costs are really at a kind of an all-time high right now for multifamily, that 10% makes a big difference. And it can make a big difference in whether or not your company manages a property versus somebody else, or it makes a difference to the owner. So, yes, if you're doing something, say something. But assume everything's important. Information dump on us. We'll let you know if something is not important, and we'll dig deeper in the weeds with you too.
And so we've talked a lot about the risk with costs associated with these liability lawsuits. But one thing we haven't really mentioned yet is sometimes the negative publicity that can come from this. So, Melinda, how can property managers best protect their reputation during and after litigation?
I think that's a tough question because sometimes there's really nothing you can do. I have seen an increase in tenants calling the news media
Mhm.
and calling local reporters, and I've seen a pretty sharp increase lately in some of my clients being prominently featured in the local news in ways that they would prefer not to be. I think again that goes back to sort of open and good communication with the resident and some sort of compassion because people go to the news and complain to the news when they're mad at
Mhm.
you. That seems to be when that triggers that the most. So a little bit of compassion and understanding and open communication can go a long way. But at the end of the day, you can't stop it. There's no way that you will be able to completely 100% prevent any of that from going on. And you just sort of have to let it go to the best of your ability and just understand that person is allowed to say whatever they want. It's a free country. They can, I mean, within limits, of course. We do have defamation laws, but for the most part, somebody can trash talk you up one side and down the other, and there's not a whole lot you can do about it other than just showing through your actions that is not true. We had a couple slides back where was a mention about garbage on the property. I think cleaning up the property and making sure it's free of trash to the best of your ability goes a long
Mhm.
way. Just from a bird's eye view, if a reporter goes over to a property and sees bags of trash or piles of trash, it gives the appearance of poor maintenance, whether it's true or not. And so it just, if the property looks nice and it looks clean, it doesn't have to be brand new, but just clean and well maintained, that is very important.
I so agree with that. Housekeeping is number one. Just having that appearance. I would also say it's important for everyone to know that these days insurance companies are going to Google every location. So if there's something in the news, tell us, let's talk about it. And let's talk about what happened and let's talk about what you're doing to make sure it doesn't happen again. Because if we can go to an insurance company and make a better case and just say, okay, this happened. Yes, there was a slip and fall, but here's what happened. Yes, we had a snow removal procedure. However, the truck couldn't get there in time. They couldn't remove it. The ice was so bad, they were overwhelmed. And we called for backup and they couldn't make it. Being able to make a case for why something was unavoidable or that in the future there's a way to avoid it is really key as well. So we really want to paint you in the best possible light because accidents happen. It doesn't always mean that that you had a high level of liability for it. But if it's in the news, it's going to be out there. Let's just combat it with better information.
But do not give a statement to the news yourselves. Don't do it.
Agree.
Keep your
Agree.
mouth shut. The first time anyone hears your version of what happened should be in court. I
Mhm.
don't want to find out that you gave an interview to that reporter because then I have to deal with whatever you said, potentially impacting you going forward. Whatever you said is going to be held over your head throughout the rest of the case. So even though it is extremely frustrating to see articles come up about, calling you guys slum landlords or whatever else, do not talk to the news. Don't do it.
Right. Yep. Very important reminder. Thank you, Megan. Thank you, Melinda. A good question in the chat before we move on here quickly. So, talking about public sidewalks in urban areas. So, for instance, having concrete that the property owner reported to the city for repair, but then a subsequent slip and fall occurred in the meantime.
Boy, that's a tough one. Can I be honest? Because I have had suits brought against a property owner and it happened on the sidewalk adjacent to their premises. And because they were aware of it and their tenants were worried about it and sometimes say something about it, they've actually been held liable. I've had, I'm just going to say, shootings on sidewalks off the premises. They were public sidewalks. The person crawled onto the premises and the owner was found liable. I have to be honest, it still floors me. And this becomes a legal issue, but from an insurance perspective, I have to say I would still find a way to handle it if you possibly can, because it is still possible to be drug into a suit, even though logic tells you no. I've seen it happen.
And I
Melinda.
think that's where maybe a duty to warn could come into play.
Mhm.
I was walking in my neighborhood a couple days ago, and somebody had put a sign out on the sidewalk that said, "Be careful, wasp's nest." And I look up, and sure enough, there's just this massive wasp's nest in the tree over the sidewalk. Now I live in Baltimore City, so it's kind of a gray area there. Who's responsible for that? Is it the city? Is it the property owner? I
Mhm.
know if somebody slips and falls on my sidewalk in the city when it's icy out, that's potentially my problem, because even though the city maintains the sidewalks, I'm responsible for keeping it free of snow and ice and other potential hazards. So I would say if it's feasible and practical to somehow warn people, hey, there's an issue here, that is helpful. And also
Mhm.
document the fact that you've called the city and you've made requests for this repair, because then you can sort of pass the buck to them. If you get sued, you can turn around and sue the city and bring the city into the lawsuit and say, look, hey, it's actually their fault. And then, then it becomes kind of like a Mexican standoff. Sorry, I was trying to figure if there was like a politically correct way of saying that, but and then I couldn't think of one. But that way, keep in mind that there may be some other responsible parties, and if you need to bring them into the litigation, then that's what you do.
So let's keep moving. We've talked a lot about the befores, the after, the slip and fall. What are some practical steps that you can take now? So I'll just run through these real quick and then I'll pass it off to both you, Melinda, and Megan to make some additional comments. But first and foremost, audit your property. Walk the property
Mhm.
with your maintenance supervisor and take note of any issues that you think could lead towards a potential liability lawsuit, and document and make a plan to fix. Improve your inspections and maintenance logs. You can institute case management templates and tools and implement those now so that you're prepared if a liability lawsuit does present itself to you. So you're not scrambling around trying to put a practice into place. Go ahead and do that now. Leverage your legal and insurance partners like Megan, like Melinda. Go ahead and reach out to your local counsel and make a plan. And then consider tech solutions like adding AI surveillance to your camera coverage, making it quick and easy to search through your footage, and making sure that you have cloud storage and that storage so that you have that surveillance available if a slip and fall case does present itself to you. So Melinda, what are your thoughts on some practical steps to take?
I think that these are all good practical steps. Again, just do regular walks of the property, regular surveys, write down any issues, things that you wouldn't necessarily think about, but the little things. If there's a light bulb out, that could potentially lead to a claim later on because the lighting was poor. If you notice that there's trash on the ground, pick it up. Just do the little things, and they will all add up and hopefully present bigger problems down the line. Make sure that you document all of those efforts, because cases are won or lost on documentation. Make sure that you have regular communication with your legal counsel and your insurance companies. Even if you're not sure if something is going to be a problem, let me know now before it's a problem. That way we can start to plan and maybe get ahead of it before it gets out of control. And then, I know not every attorney is going to advise you to get surveillance on your property, but I think it can actually be a good thing, because that way, at least for better or worse, what happened. And if it turns out that it was something that you are going to be liable for, you can nip it in the bud and you can settle it quickly and quietly. And
Mhm.
that may be the best outcome possible for some cases.
Yeah, I would agree with all that. I would also add to that that your insurance broker is your advocate. They don't, unless it's a direct writer like a State Farm Farmers. If you're working with a broker, they're your advocate. And so it's really in all your best interests to have somebody work with you on loss control. What are your procedures? Walk the premises, particularly if you have premises that have had some issues. Let them walk with you. Let them talk to you about things you can do. We are not obligated to share anything we find with the insurance company. It's between us and our clients. So I think take advantage of a resource would be strong advice, and save any footage of an accident.
Yeah, I never want to hear, oh, we do have cameras, but we
Yeah.
don't have that footage anymore. Well, that does not help me at all.
Yeah, and that kind of leads us to this next slide here, before we kind of come to an end. But you might have cameras, but make sure that they work first and
Yes.
foremost. And so Cloud Structure offers this awesome feature where if a camera goes down, it will notify you. And our team also helps to survey that for our clients as well. But making sure that your system, your surveillance is up and running as it should. Rapid search, that's going to help you and your litigator when it comes to looking through that footage to find what you're specifically looking for, making sure that you have storage and the ability to save a clip for longer than the 30 days. As Megan mentioned, or maybe it was Melinda, but in the contract, I think it was Megan, it might say that you have 30 days of storage. Call them up and ask them, hey, I need this clip for longer. There's always a way around that. Watermarked footage. Melinda made the comment, if there's no date on it, it's pointless. So make sure that it's watermarked. And then also comprehensive incident reports. So with Cloud Structure, with remote guarding proactive piece, anytime an incident happens on property, we follow it up with an incident report that gives great detail. That documentation that both Megan and Melinda have driven into our minds that breaks down what happened, who was present, where it was, what date, what time. So we do that for you. And as I mentioned before, remote guarding really offers that preventable aspect and that proactive aspect to security. And before I play this quick video, Melinda, is there anything you would add about the importance of surveillance with liability lawsuits?
Look, I tell clients this all the time. You can't change the facts. You can't go back and reverse what did or did not happen. And so that's not really ever my function. My goal when I handle big litigation like this is to figure out what happened and then to sort of figure out the best path forward. And sometimes that's just accepting responsibility and settling the case. I know no one ever likes to do that. I don't enjoy telling you guys to give away your money at all, but sometimes that's the most appropriate course. So if you have clear evidence of what happened one way or the other, that is the perfect starting point for me.
Megan, what are your thoughts on surveillance?
I'm a big fan. And I will tell you, I'd much rather be talking to you about this before you have an incident than after. But I will tell you, it will save your bacon after as well. So, big fan. We talk about it a lot. And trust me, every insurance company is going to ask you about it.
Okay, this is just a really quick kind of highlight reel of surveillance and slip and fall liability lawsuits.
Slip and fall lawsuits happen by the tens of thousands every year. Property managers are often the ones in court, and I should know because I represent them. The problem? Cases can be filed years later, long after staff or residents have moved on. By then, witnesses are gone and memories fade. And that's exactly why surveillance matters. Video shows if a case should be settled or if it should be fought. You need to get a system that stores footage securely, checks camera health, and gives you the case management that you need, because your best defense against liability is a clear record of the truth.
Again, just speaks to the importance of having that surveillance, which can save you in so many different aspects, not just liability lawsuits. Would you guys like to see a personalized demo of Cloud Structure's AI surveillance system with myself? And also, would you like to register us for our upcoming webinar? It's going to be focused on construction theft. So another really exciting topic. I do want to take a moment to thank Melinda and Megan, both of you, for adding your expertise to this webinar. That was very informative and incredibly helpful to have both the perspective from a litigator and also an insurance broker as well. So thank you both so much for joining this awesome webinar.
Thank you very much. My pleasure.
Again, if you have any questions, you'll see my email as well as Melinda's email. Go ahead and reach out to us if you have any questions. And if not, have a great rest of your day. Thank you guys so much.